A very good afternoon, everyone. Today I welcome you on behalf of Maharashtra National Law University, Mumbai, Center for Arbitration and Research to the Oxford Style Debate. The motion is India needs a standalone law on domestic arbitration. And we have the privilege of having speakers and juries who are well known in the field. As far as jury is concerned, we have the privilege of having Justice Hemant Gupta, who is a former judge, Supreme Court of India, and presently Chairperson of the India International Arbitration Center. We have Dr. Sanjeev Gemawat, who is Group General Counsel with Vedanta Resources. He is a faculty at the university. He regularly teaches at our postgraduate diploma program as well. As far as for the motion is concerned, we have Mr. Ajar, who is a leading arbitration practitioner. And we also have the privilege of having Aseem Chaturvedi, who is a partner with Khaitan and Co. As far as against the motion is concerned, we have Tejas Karia, who is head of international arbitration practice with Shardul Amarchand. And we have Ms. Bindi, who is partner with Wadia Ghandy. And most importantly, organizer of this program with me, Mr. Vyapak Desai, head of international arbitration practice and litigation at Nishith Desai Associates. Our knowledge partner for today's session are HCC Online, EBC, and Young MCIA. So with this small introduction about the panelists, let me speak something about the debate. Currently, we have Indian Arbitration and Conciliation Act 1996, which is modeled on model law of 1985, and we have two parts, Part 1 and Part 2. Part 1 deals with domestic arbitration as well as Indian-seated international arbitration. And Part 2 deals with enforcement of arbitration agreements, which are pertaining to foreign-seated arbitration agreement, and Part 2 also deals with enforcement and recognition of foreign arbitral award. So the debate is of twofold, whether within Part 1, whether domestic arbitration and international arbitration should be dealt by separate laws, and even for Part 1 and Part 2, should there be separate laws? This is not a unique debate. Way back in 2003, when when arbitration bill was introduced in the parliament, there was a proposal that there should be a separate law for domestic arbitration and international arbitration. The bill was introduced in the parliament, but could not go through. Here we are in 2023. Again, there is an expert committee which is reviewing the arbitration regime. And again, one of the agenda before the expert committee is, should we have a separate law for domestic arbitration and international arbitration? It is in this backdrop we have initiated this Oxford style debate so that we have the suggestions or recommendations, perspectives from both the sides as to what should be the direction of the arbitration in our country. Because many a time when we say there should be two separate regimes, outside world as well as practitioners within the country may start thinking like that we are getting hostile toward arbitration and domestic arbitration is being given a stepmotherly treatment. Whereas there are some practical reasons why domestic arbitration and international arbitration should be separate. As Professor Jan Paulson famously stated, international arbitration is not arbitration. He meant to state that international arbitration does not have any alternative. There is no international court, but domestic arbitration, it has alternative in form of court. Or there could also be statutory arbitration and other dispute resolution mechanism. So the debate must be understood in this sense. I must also put a disclosure that the views expressed in today's debate are not either the firm's view or the organization view, or they may not even be the personal views. These are the arguments presented by the debaters and the speakers for the purpose of this debate only. So with this small introduction about the debate, I now invite Vyapak to lay down a formal framework for the debate. And thereafter, I will invite one speaker for the motion, other speaker against the motion. Again, we will have in turn for the motion, against the motion, and only speakers for the motion will get the rebuttal. So that's the structure of the debate. And after Vyapak speaks, we will put a poll to you. Please give your opinion. And after the debate, we will give the poll to you. And towards the end, both the members of the esteemed jury will share their verdict or their opinion about the debate. With this, Vyapak, I pass it on to you.
Thank you, Chirag, for the introduction, and congratulations to MNLU and Chirag and your team to come up with this topic at this opportune time when the whole arbitration law is put up for a rethinking. And it could not have been a better time to have this debate. Real congratulations to all of you. And of course, thank you everyone who is participating on this debate, because it's not easy to, get that time, and, it's a serious topic, so it requires a lot of preparations as well. As Chirag said, it may not be a personal view in that sense. And more importantly, thank you, Justice Gupta and Mr. Gemawat, for accepting to be part of the jury and making this debate worthwhile for all the participants to attend. With that background, I think the topic obviously is of a prime importance, and particularly for India, this topic has been in discussion since the 1996 Act. Prior to 1996, as we know, the arbitration law was divided into different statutes for the arbitration and for enforcement of foreign awards and so on and so forth, because it evolved over a period of time since 1940 till 1996. 1996 is when India adopted the Int'l model law and made a composite act called Arbitration and Conciliation Act, which Chirag just mentioned, how Part 1, Part 2, Part 3, and Part 4 are aligned, covering arbitration with substantive and procedural provisions as Part 1, enforcement of foreign awards as Part 2, conciliation as Part 3, and miscellaneous provisions at Part 4. But then we saw what happened between 2010 till almost up to 2012, where Wadia International and Venture Global created almost a havoc, if I may use that word, to bring in foreign seated arbitration into the realm of Part 1 for Section 9 and then Section 34. And then the whole act got very complex for the purposes of interpretation, and also some of the judgments came in which possibly were not intended to when the 1996 Act was amended, or rather promulgated through an ordinance. 2012, obviously, Balco brought the sea change by making arbitration law in India a seat-centric law. And when I say seat-centric law, Balco basically said that everything depends upon where is the seat. If seat is in India, then Indian law applies. If seat is not in India, not even Section 9 applies. And that was an extreme view. So the pendulum went from left to almost extreme right. And then we got our 2015 Act, where seat-centric law was little bit diluted to say Section 9 will still apply to foreign seated arbitration unless parties choose otherwise. While our definition divides the Arbitration Act, particularly Part 1, not based on seat, but based on the kind of parties. That is to say, if it is two domestic parties, it's a domestic arbitration. If one of the parties is international, then it is an international commercial arbitration seated in India. And then again, the contours of Section 34 and patent illegality are different in these two kinds of law. So one can understand, right? There is so much of overlap and confusion. One, it's a domestic arbitration, domestic award when two parties are Indian. It's international commercial arbitration when one party is non-Indian, but still it's a domestic award challenged under 34. And then there is a foreign award where now even two Indian parties can have a foreign award because they can seat their arbitration outside. So I think I'm just putting why this debate is important. I'm sure both the sides have strong arguments both ways. And it's not something unheard of. If I am not wrong, Singapore, Switzerland, Australia, and a couple of other countries do have separate laws dealing with this aspect. But then, as I was talking, you will have to clarify whether we are dividing the laws based on seat or based on the kind of entity that is domicile or incorporation of that party. So far as the domestic versus international commercial arbitration is concerned. So I think there is a real need for clarification. There is a lot of complexity, a lot of overlaps. Whether India will be better off with or without domestic law, we'll know it by end of this debate. So without going into the aspect, because I don't have to do the difficult job, I will let Chirag introduce the real speakers for the session today, and would love to listen them and see what comes out of this debate. Thank you every participant for joining this session. And my understanding is that we are going to publish some outcome of this debate as well, if not in form of a white paper, but at least pointers, so that the committee or at least the people who are looking into this aspect may at least look at it from the perspective of the real, people having both sides' views for the consideration. So it's not a simple debate going, without any consequence or any impact. It is definitely done for a purpose, and hope everyone enjoys it, but also takes some benefit out of it. So thanks, Chirag, again, and over to you.
Thank you, Vyapak, for putting it so eloquently. Now, let's start with the debate. But before we go to the debate, let me do a small poll. Please participate in this poll. Kindly give your vote. Come on, be quick. We are receiving responses. Yes. Yes. Counting is going on. Yes. I think now I should end the poll. Yes. Do you want to know the results, or should I keep it for later? I'll keep it for later, I think.
Yeah, so either now or later, but do tell us.
Yes, yes. So, yes, I invite first speaker, first debater of the day. Every debater will get 10 minutes to present the side uninterrupted. And if there would be any audience question, please share them in the chat box. We will take them in the end. So, Ajar, I invite you to present your side for the motion. Your 10 minutes starts now.
Right. Thank you, Chirag. And it's my pleasure to be here. And good afternoon to the honorable members of the jury, Justice Gupta and Dr. Sanjeev. So I'm going to make typical Oxford style threefold submission, I have 3 points to make. Number one, what is the difference between a unitary and a dualist state? Number two, what is it that India has done so far? And number three is, how would a separate law address those issues? And then I will leave it to my esteemed colleague Aseem to address what are the practical aspects that India needs to look at. So whenever we think of a unitary system or a dualist system, as Vyapak rightly pointed out, there's examples of Singapore, Australia, Switzerland, some part France, some part Brazil. The question that we're really asking is, do we need more court intervention or less? It is actually the degree of court intervention which will determine whether we need a separate law or we need a unitary law addressing both aspects. And if just one were to take the example of Singapore, the way their domestic arbitration differs from the international one, it is that there is an opt-in or opt-out provision, which was what happened in Hong Kong also up to 2017. There's an additional right of appeal against an award on questions of law, and the court has certain extensive powers of interim measures. And lastly, the court may vary, confirm, or remit the award, something that is not possible under the model law, right? And that brings me to the most fundamental question that requires this attention of this panel today, which is that why did the model law take a unitary approach to domestic and international arbitration? And I think the answer is that the monoism or the unitary aspect came from the New York Convention. Because what the New York Convention said was that grounds for recognition and enforcement and grounds for setting aside were kind of harmonized. And without that harmony, you could not have an enforceable award being used across jurisdictions, right? So to that extent, I think two questions come up. Number one, is the same approach required in domestic arbitration? Do we need to address a conflict of law situation? And the answer is no. The second is, the model law was intended for international harmonization, but that international harmonization has led to a disruption in domestic arbitration. We have several instances of courts misapplying or choosing or cherry picking jurisprudence which technically does not apply to domestic arbitration and applying it like it was an international arbitration. And I think the biggest catastrophe, like Vyapak said, was Wadia, right? So the question that is that harmony required may not be, because the reason the model law came was it wanted a framework which was acceptable to all states, regardless of their legal system or economic situation, right? And what the model law really achieved was four things. One, enforcement of the arbitration agreement. Two, setting aside of limited grounds. And three, court intervention. And lastly, party autonomy, right? And these hallmarks, especially limited court intervention and party autonomy, are also equally present in the domestic law of all these dualist states, whether France applies a different law, Singapore, Switzerland. And therefore, the question is, do we need to imbibe what the model law did in order to be a more effective jurisdiction? And we have enough examples to show maybe not, right? Now comes the amendment to the 2006 model law, where Article 2A was introduced, which said regard is to be had to the international origin to promote uniformity in its application and observance of good faith. Right? I will come back to this point, but there is a large academic literature which suggests of an international public policy, which is dehors your domestic law and domestic procedures. And therefore, if we were to separate, would we not become more pro-enforcement, right? So that was the first part of my submission. Now I come to the second part, is that what are the problems currently in India? Do we need more court intervention or less? And I think I'm going to pick examples from the Arbitration Act. Section 8 uses a different test for prima facie jurisdiction for domestic arbitrations. and the model law test of null, operative, or incapable of being performed for international arbitrations. Right? Then you have questions of stamp duty. Everybody has read everything about NN Global recently. This does not apply to international arbitration. Section 11 then distinguishes between appointments of domestic arbitrations by the High Court and international arbitrations by the Supreme Court. The reason we needed a Schedule 4 is because there were problems in domestic arbitrations where arbitrators were charging exorbitant amounts of fee. You then had to introduce timelines because we were not wrapping up our arbitrations on time, and then effectively remove timelines for international arbitration. And then, as we all know, Section 34 had to come up with patent illegality, right? The Supreme Court in Shri Lal Mahal and Progetto said that public policy should be construed narrowly in international arbitration as opposed to domestic arbitration. So what I'm really getting at is, are we already not a dualist state? We may be applying the Arbitration and Conciliation Act as a standalone legislation, but look at our provisions. Our interim measures are borrowed from England, which is not a model law jurisdiction. Our timelines are borrowed from Brazil. We don't adopt the French approach of pro-arbitration. Then all our sections, our fundamental procedures, have already been amended by 2015 and 2018 and 21 amendments. We are already a separate dualist state. It's just that it is an implied duality. Now I come to the last leg in the final 2 minutes of, if we were to adopt a separate law, number one, parties would actually have more autonomy for choosing an opt-in or opt-out, something that Bhatia wanted to do but went sideways. I may opt for a less interventionist regime if I opt for international application, which is permissible in Singapore. Second, if I do that, I can choose the system of law, which is adversarial or inquisitorial, that I then have that party autonomy as well. Third, like Vyapak mentioned, we can remove the characterization of domestic and international based on territoriality and location of parties and make it an opt-in, opt-out mechanism. Then there is a lot of confusion over seat and venue, despite BALCO. We have international jurisprudence being applied to seat and venue debates in India. We also have a problem under the CPC, where Section 16 to 20 apply differently, and therefore, where will you go for jurisdiction? A separate domestic law would be able to better address these issues. One academic point which is made is that there are gaps in the New York Convention and the model law, and a domestic law can be used to fill those. Like I said, this can also take into account consideration of stamp duty. There is no bar in having a separate law to align with Article 2A of the model law, right? And I think the biggest question, and I think all practitioners here would agree, is that many a time we are faced with an award which is so perverse that you would rather have an appeal against it and the parties get finality on that question rather than restart the arbitration. So is it not time to allow domestic courts to confirm, vary, or remit the award? Remission is still allowed, but recently, I think 3 days ago, the Supreme Court said you have no power to modify the award, right? Are we better off modifying the award now or restarting the arbitration after 10, 15 years of litigation? I think the most fundamental point is the reason setting aside the way it was envisioned in the model law was that foreign courts could not apply substantive law of another jurisdiction. That would not happen in domestic law. And therefore, appeal on questions of law should also be permitted. I think I will leave the floor, I see my time's up, with 3 questions for my esteemed colleague Tejas. Does a unitary system make a more robust arbitration regime and foster arbitration jurisprudence? 2, is an inconsistent unitary system better than an effective dual system? Or 3, doesn't a separate regime give a better signal of India's commitment to international trade? Thank you.
Thank you, Ajar, for completing it on time. Now invite Tejas to present the counter arguments.
Thank you, Chirag. Good afternoon, Justice Gupta, Dr. Gemawat, my fellow panelists, Vyapak, and all the participants. It's my pleasure to speak at this debate at MNLU. And the topic is very interesting. I'm part of the expert committee who is looking into the very same issue. So we are grappling with this issue. Of course, the views are not personal here. We have been given a side. So I'm just doing my debate here. So the question which were posed by Ajar and rightly so is that do we need to have a dual system or a unified system? And if we go back a little bit, we will realize that we had triple system. We had 3 laws. We consolidated into one. And we have seen over last 25 years or more, maybe, that we have done a good job with our laws. The idea, we refer to model law. We are a model law country. And the idea was of the model law also to unify the arbitration law across and have a uniform standard across jurisdiction to promote trade. And if we were to do so, why should we treat our domestic arbitrations separate from international arbitration? Interestingly, domestic arbitration is not defined. Although we have a definition of international commercial arbitration in our act, the domestic arbitration is not defined. You have a domestic award, which is seated in India. As Vyapak said, there are 2 concepts. One is the international arbitration concept, and the other is the foreign award versus domestic award concept. So we need to see the way we have structured our law at present, whether do we need to now create a clean slate and start all over again, because we have a very active judiciary. Our judiciary has taken a pro-arbitration approach. We have come a long way by having developed the jurisprudence over the arbitration. I heard Ajar talking about a lot of problems, but I didn't hear him saying what's the solution. And is the solution having a 2 separate law? I couldn't be convinced by his debate. Maybe Aseem would be able to convince me more after I finish. But let us understand what are the advantage we may achieve if we separate it. Maybe we have a separate applicability of the court intervention, but we have it. We have changed the definition of court in 2015 amendment. I was again part of the Law Commission committee where we debated extensively what is the problem, and exactly the problems which we were talking about, we debated and came up with the solution. And the solution was that all the matters relating to international commercial arbitration will go to the High Court. We had already a distinction between the appointment of an arbitrator going to the Supreme Court as vis-a-vis High Court for domestic arbitration. Then we also realized in 2019 that, look, the timelines which we had proposed is not working out for international arbitration, because mostly international arbitrations are institutional arbitrations, and institutional rules have their inbuilt timelines. So you don't have to impose timelines on the international commercial arbitrations. So we have a different treatment within our act. Just by making it 2 separate acts is not going to achieve anything what more we can achieve, and we have achieved till now. Of course, we have a patent illegality as an additional ground, but again, that was necessary because the very same reason I just said, that the domestic arbitrations are different. So we have to treat it differently. Personally, again, I feel that we should not have had patent illegality for domestic arbitration, because when we do domestic arbitrations, we wear 2 different hats, as we where the same lawyers will do international arbitration differently and domestic arbitrations differently. I ask myself, why? Why do we need to do that? Are 2 Indian parties not commercially astute and sound to do the arbitration the way the international parties should do? Why should we go to court when we have a alternative dispute resolution, which Vyapak always says is not alternative but parallel, and which I agree with him, is that why are we relying on the court? Why are we even thinking that the courts can resolve these complex commercial disputes? And we need to bring arbitration out. So what we need to change is our mindset rather than the law. If we change our mindset and we start thinking that arbitration, the way it has to be done, is only one way, which has no baggage of the court system, no hangover of the procedural rules or evidentiary rules, and what we need to achieve basically is a speedier, less expensive and efficient result, which is final and binding. Ultimately, if we talk about Singapore or Australia, and Hong Kong was dual, then it became single again in 2011 with the opt-in, opt-out model. we have to see that what is the experience there. The experience there is only with regard to the court intervention. In the International Arbitration Act, they don't allow court intervention, whereas in the Arbitration Act of Singapore, they have slightly more court intervention on the question of law. We have already achieved that. We have done 34(2)(a), which is a separate ground for a challenge of award on the ground of patent illegality, which is not available with the international arbitrations. Again, we have, I heard saying that this Section 8 and Section 45 have different standards, but again, if you see the case laws, they have now blurred the distinction. They have treated 4 and 8 as the same. And why not to see, because arbitrability in India, because we have to also see that the award passed in India conforms with the public policy of India. And therefore, before referring the matter to arbitrations, the court should have prima facie view, and it is only prima facie. And we have series of judgment which says that everything should be left to the arbitrators. And I'm sure this stamp duty is a temporary problem. The curative petition is going to be heard. And of course, we failed at one round, but our courts are alive to the problem. So it's not that once a bad judgment comes, we have to just throw the baby along with the bathwater and just come up with a new law. That's not the idea. The idea is basically to streamline. What is this expert committee doing? They are actually streamlining the whole process of arbitration. Of one of the grounds which we have before the expert committee is also to consider the very same aspect which we are debating today. But I would like the House to believe that ultimately what we need to achieve is a user-friendly arbitration law. Just by dividing into two, it's not going to help. So what do we need to achieve? We need to do basically capacity building, train arbitrators more. We should have younger arbitrators coming and sitting as arbitrators in domestic arbitrations, train them the way it should be done in the international way. We should also have specialist arbitration bar and specialist arbitration bench who can decide the arbitration related matters. So we solve all the problems which we are facing. Third is institutional arbitration. So whatever Ajar has said so far, the answer is institutional arbitration. We have Justice Gupta here, and he heads one of the top institution of country today, the institution of eminence. And that's the answer. The fees is fixed. Timelines is fixed. You have the rules where the awards are scrutinized. So you don't have any chance of going and challenging the award, which is again scrutinized by the experts. Appointment of an arbitrator, that there would be a council of arbitration who would be appointed, will be appointing arbitrators. The world-class arbitrators have to be there on the panel, and they should be appointed. As we all know, the arbitration is as good as the arbitration. The arbitration law does not make an arbitration successful or not. Ultimately, we have to see who are the people who are running the arbitration. Law is just the framework. Law cannot make the arbitration successful or not. And that's what we have seen, that wherever there were loopholes, the courts have come to our rescue. Indian Supreme Court and High Courts have been known as the most arbitration-friendly jurisdiction in last 1 decade. And the maximum number of cases on arbitration we see is coming from Indian courts. And now, if we were to start everything all over again, imagine what would happen. We will have different interpretations coming from 2 different laws. Anyways, there is enough confusion about the case laws, and every time we have conferences, every conference is a new conference we have on arbitration, where there are new case laws to discuss after every 6 months. So if we were to start all this process again and have a separate law, I don't think we will achieve anything beyond confusion. And we have to now give a clear signal to the outside world that we are ready. India is ready to take on jurisdictions like Singapore and London, where most of the international commercial arbitrations are there. This is the time where we need to bring international arbitration to India, which has nothing to do with India. No Indian law, no Indian party, but the seat should be India. That's the level of arbitration or the confidence we need to achieve. We having achieved so much, we can't go back in time and start this journey again as if we started in 1996. Of course, there are some problems, and those problems are not unsurmountable. We can definitely find solution to those problems by tweaking the law, or trying to achieve what we have done so far. So I would like to conclude with answering those questions which Ajar had put to me. Is that my view is that there is no benefit in having the dual system. The uniformity which we have is good enough, and we should build on this rather than going back in time. Thank you.
Thank you. Thank you so much, Tejas. Debate seems at this stage to be even. Let's hear Aseem and see where does he till this debate towards.
Thank you, Chirag. And good evening to Justice Gupta, Dr. Gemawat, my fellow panelists, and Vyapak, and all the participants here. Now, it's always a pleasure to have Tejas on the other side. We're mostly on against each other when it comes to arbitration or otherwise in court. And here also we are debating on this issue on opposite sides. So the issue really is that should India have a standalone law on domestic arbitration? I am for the motion. And we've all briefly touched upon that the Act does not define what an domestic arbitration is. It only provides for what an international commercial arbitration is. And I think the need is to now expand and frame a law which specifically deals with domestic arbitrations and international arbitration separately. The need of the hour is two separate laws, and not to have one consolidated legislation which creates confusion and overlap. Now, historically, there have been previous legislation related to arbitrations, and we've all in this debate itself discussed. I'm not going to repeat all of that. But the effect of one consolidated act that we've seen in 1996 was that it caused confusion related to the applicability of Part 1 and Part 2 of foreign seated awards. We've seen that while the arbitration jurisprudence is evolving, there have been repeated amendments in 2015, 19, 2021. There's a 2023 committee which Tejas is also a part of, which is looking into it. The need of the hour is not to again and again amend the law, but it's time that the time has come to cut the umbilical cord and have two separate legislations so that this confusion and overlap does not continue to run and deter international parties to come to Indian courts. While Indian courts are extremely proactive and arbitration friendly, the fact that Indian courts are interfering in arbitration matters in itself is deterring international clients and international parties to come into Indian waters. The fear that there may again be so to say a Bhatia or a Balco or other set of judgments coming in which may change the interpretation of the law. We have the group of companies doctrine deliberated by a constitutional bench, then comes in stamping. So these issues actually should only be restricted to domestic arbitrations if we really want India to become a hub of international arbitrations. And in my view, we can start with having two separate legislations so that there is no overlap and confusion with the international community as such. The Arbitration Act in its current form has Part 1, which deals with India-seated arbitrations, and Part 2, which provides for foreign awards in respect of New York Convention and Geneva Convention. While there is a distinction with respect to the two parts in the Arbitration Act, certain provisions of Part 1, such as Section 9, applies to both domestic and international arbitration. This is where the problem comes in. The Section 11, although provides for appointment of arbitrators, we have again distinguished that domestic will go to the high courts and international will only go to the Supreme Courts. The certain common provisions will apply to both domestic and international arbitrations are Section 27 and 37(1)(a), which are common in application. There is a perpetual intermingling of the applicability, which more often than not leads to various complications. Thus, Part 1, opposed to being strictly applicable to domestic arbitrations, is being applicable to arbitrations which are seated in India, which also includes international commercial arbitrations. While most of us practice in more evolved jurisdictions as Delhi or Bombay, what needs to be understood that owing to the confusion and overlap between domestic and international arbitrations, we are exposing international arbitrations and international entities to various district courts if it comes to Section 9 or a Section 34, then there is Section 37, then there is an appeal. So the timeline is infinite. The overlap is certainly there. And in my view, we can plug this loophole by coming in with separate legislation, insulating international arbitration, leaving all this interpretation only to domestic arbitrations. Section 45 and Section 8, we briefly touched upon that although they are similar in scope, but are dealt differently. What I need to deliberate a little upon is, and to try and convince and tilt the pendulum to my side, is the issue that the Part 1 or Part 2 and the committee of the 2023, while they're deliberating into it, they must realize that the international law aspects are very, very different from Indian domestic law. While some countries have common law, some countries have civil law, the domestic Indian law will be very different from several jurisdictions in the international concept. The public international law will also come into place when there is international arbitration, and thus it is best that we enact separate legislation and keep both the arbitration law separate and distinct. While in most domestic arbitrations, the substantive law and the curial law may be same, but that will not be the case in international arbitrations. The complexity of international arbitration in terms of choice of law, seat, venue can be very different, and it is high time we recognize the difference and deal with them by means of a separate legislation. Singapore, for once, has emerged as a hub. And what I feel personally is because there is so much clarity. There is separate law for both domestic and international arbitrations. They have a, not that our centers are in any manner less, but they have tried and tested. People have clarity. Clients are very, very comfortable going to Singapore. And I think that clarity and comfort can be given if we have separate legislations for domestic and international arbitrations. Also, when the rules and procedures applicable to domestic and international arbitration are separate and distinct, then why shouldn't the legislations be different? Most leading arbitration institutions in India and overseas also have separate rules and that govern in domestic and international arbitrations. So the time is that we separate the legislations as well. Having separate legislation will not only be in line with latest global practice, but would also bolster confidence in India as an arbitration hub. The objective of providing and achieving ease of doing business would also be strengthened, paving way for better foreign investment into India. With the large scale and enhanced attempts to procuring foreign business and also support Make in India campaign, a certain comfort needs to be provided to the foreign players to enable them to have confidence on not just Indian market, but also the Indian legal system. Eminent jurists, judges of the Supreme Court have also impressed upon the need to have separate legislation for domestic and international arbitrations. Justice Indu Malhotra, in a conference in February 2023, had said that there should have been two acts, one for domestic and one for international foreign awards, because the regimes are absolutely different. Sometimes in the interpretation of one part tends to have an overlook on the other part and create more confusion. And most of the panelists here, in my view, are, so to say, guilty of repeatedly advising and we all getting into amendments and getting interpretations from court. But to put all of this together, I don't think we will be setting the clock back. I think we will be giving more clarity if we come up with different legislation, and it is absolutely the need of the hour in my view. And I would like to end with that. And maybe in rebuttal rounds, we can have more debate on whether Tejas's views or my views are at this time better or for the worse.
Thank you. Thank you so much, Aseem. Let's move to Bindi. Your thoughts.
Yes, thanks. Thanks, Chirag. Hello to all my esteemed colleagues, respected Lordship. Thank you for having me here. I've heard Ajar, and of course, Tejas has dealt with that. I will respond to Aseem's views. I was, wanting to deal with, the grounds, if any, which would have been made for want of a separate law. And while Aseem has made out, a case, I did not hear, a specific ground or reason as to why, according to him, we need a separate law. So I'm a bit at a loss, as to what I'm supposed to respond to. And therefore, what I will do, is give my views as to why I think that that is not required. I'm speaking against the motion. And while, of course, these are my personal views and not of the firm, but, and of course, even I have been given, the slot to speak. So I'm speaking, but these are my views too. So I'm saying what I truly mean. As I said, I did not hear of a specific ground or reason for requirement of a separate, law for the domestic arbitrations. But, since I was given this topic, I have done some research. And of course, in our practice, we've come across where the one compelling factor or reason, which I thought, could be a reason, was want of interference by courts. And I'm assuming that is the main driving force behind this. So, of course, my views are against it. And before I come into that, I just thought that a bit of history is required as to how we've reached where we've reached today. So, of course, you all are aware that we had the 1940 Act and we had a separate Foreign Awards Act, and we've had a whole, Int'l model law, which was laid down, and we've adapted that in 96. And then, of course, there was some further thinking done because of the problems that we were then facing. And that is how we had the 2015 amendment. All of that had actively considered, amongst several other things, even this requirement, whether this was a requirement, whether we needed separate laws, all of this was completely examined. And as Tejas said, he was a part of both of the committees where this aspect was clearly gone into. So a lot of thought has already been, gone into this. They've examined it, they've considered it, and what we have today, which I agree with, Ajar as he started, we actually have a dual system. While it may be consolidated and combined into one statute, we actually have different provisions. Wherever the legislator deemed it appropriate and required, we actually have separate provisions or a difference in the provisions for domestic arbitrations and for international commercial arbitrations. So those checks and balances have already been built into the law as we speak. I've not heard of any reason, either from Ajar or Aseem, as to what is the need today, what has changed since 2015, or for that matter, even since 1996, which wants a requirement of this very aspect all over again. I agree with Tejas that we have to move forward. It seems like we are all wanting to move back, and while I'm not saying yes or no, but one must understand the reason before we go into examination of whether it's required or not. What is the reason? I mean, I'm not hearing anybody say that. And as Tejas rightly said, these aspects have already been examined in there. When a party chooses arbitration, whether it be Indian party, domestic party, foreign party, a commercial business house, whoever opts for arbitration is conscious of the fact that he has opted out of court. Once that decision is made at the time of the agreement itself, that decision is made. Once the party has made this decision, then there is the question of wanting further court interference. So it's a question which I'm grappling with, that once a party has chosen arbitration, then why does the same party want court interference? And that is the way the entire world is developing, the economy is developing. Why does India, want to be on the back foot? We've already taken a step ahead. Why are we kind of looking at it, again from where we had started off? And referring to what Aseem was suggesting, I couldn't understand whether his concern was that the tests of domestic arbitrations were being applied to international arbitrations, or the rigidity which otherwise is required for the international arbitrations in terms of, say, challenge of award and all of that are kind of being applied to domestic. I would have thought the concern should have been that the stricter tests are being applied to domestic arbitrations, and hence, that should be opened up and whatever. But I heard him to say the otherwise, where, international parties are made to come to Indian courts, and, the domestic arbitration tests are being applied and all of that. I don't think that's the problem at all. So, with due respect to my colleagues here, I've not heard of any compelling reason as to why should we go back in time and have a separate system have a separate law for domestic arbitrations. I think our law as it currently stands, is dual in nature. The legislature, in its wisdom, has culled out, as and when required, separate provisions for international and domestic arbitrations. I don't think they are being painted with the same brush. I think the courts are interpreting them with keeping in mind the intention of the legislature. And I don't see any problem. In fact, I'm surprised that this aspect is being even considered by the committee, since this was very well considered on the last occasion, and appropriate provisions, appropriate provisions have already been, made in that regard. So I would, I am not, of course, agreeing with the motion, and I think there is no need for any change. If at all, any specific provisions or concerns would have been identified, amendment, of course, is something which is more appropriate as opposed to having an overhaul, substitution with new law or a separate law. So if any specific compelling provisions or concerns would have been pointed out, my suggestion would have been to consider amending the law. And only one aspect which I have, and in the other aspects which the committee is examining, which I have not just experienced, but I completely relate to it, is, which even I think Tejas and Ajar touched upon, is, empowering the courts to modify the award, as opposed to relegating them to a whole new round of arbitration, if the award is set aside. And that is same for domestic and international. So that is one thing that, in the amendments and the committee who's examining is what, my recommendation, my suggestion would be that empower the courts to do that. And as I said, if there's anything else, any other concerns, any other specific provisions that need to be looked at, if at all, then that can be considered by way of an amendment. I don't think we need a separate law, for domestic arbitrations. I hope I've covered.
Thank you, Bindi, for the compelling arguments. Now I invite for the motion team to make a rebuttal of 2 minutes. Either you can make a joint rebuttal or 1 minute each. Both of you can speak.
Right. I think this part we didn't discuss. So Aseem, maybe I'll just take a minute and
Yeah, go ahead.
All right, I'll address both Tejas and Bindi's two primary arguments that Aseem and I didn't offer too many solutions, but I think our focus was more on how this would actually foster more autonomy. And the idea is that instead of harmonizing with the model law, you can harmonize with your mandatory law by a separate domestic legislation. And that in turn would, like Bindi also said at the end, would permit, let's say, either an appeal or a power to modify the award. And at some points, we also have to account for statutory arbitrations that we have created. Is the model law a regime that really suits statutory arbitrations? There are questions that have come up for jurisdiction which require answer, and I don't think 16.5 is the answer that you wait till setting aside of the award. Just last 2 points on, are we really stepping back? The whole point is, if you see the most progressive jurisdictions such as Switzerland, France, or even England, they didn't completely imbibe the model law, and they are considered to be the most pro-arbitration jurisdictions. So it's not that if we have a separate law, we're going to step back. The whole point is this need has arisen because so many amendments were required to make that distinction between domestic and international arbitration. And therefore, if we were to, like Aseem said, evolved jurisdictions such as Mumbai and Delhi are okay. But what happens in commercial courts in districts is a completely different ball game. A standalone law harmonized more with your mandatory law in terms of civil procedure or other requirements would, to my mind, make a more clear, precise distinction between what is expected from the courts when they're dealing with domestic arbitrations and leaving the international to, as has already been done with the High Court or the Supreme Court. That's it from me, Aseem. Thank you.
I'll just take a quick 30-second rebuttal to what Tejas pointed out, that the idea is not to come up with a new legislation, but let the judiciary interpret. I think it's high time the legislature steps up and does its bit rather than every time we going back to the judiciary and seeking help in interpreting every section, every amendment. The idea is that if a robust legislation comes in, which is in sync with what is happening in international jurisprudence, then that will help in, number one, giving more strength to the arbitration regime in India, and also to the international players having more comfort and clarity in coming to India and making India the international hub that we've been deliberating for so long. Those are the only 2 pointers for me.
Thank you, Aseem. I do have some thoughts. It is such an engaging debate. I'm very tempted to speak and take sides, but I will resist myself as a moderator. So I think that that's the end of debate. Now we will move to our jury. Sanjeev ji, would you like to pass your verdict. And then, yeah.
I think, I completely agree. Absolutely engaging, discussion. Appears to me the objectives of both for and against, objectives were the same. End result is the same. But then from a process standpoint, both were having, I think, different perspectives. I like when Ajar said that what do you want, more court intervention or less court intervention? I like that phrase. As a user of this ecosystem, I feel frustrated at times that it is too much of court intervention. But then Tejas is also having the similar views at the court intervention. But then somewhere I think both of them were very good in terms of their arguments and communication. But personally, and Chirag, I'm allowed to use my personal views. Am I correct? Okay. So personally, I would go with Tejas and Bindi largely because the experience suggests so far that the enactment of a legislation perhaps not serve the purpose because the judicial innovation at times is so high that at times we don't do justice with the legislation. And I'm just giving you an example because even if you have two separate laws, whether that would do justice as far as the overall justice delivery system is concerned, perhaps answer might not be so perfect. Because let's accept this reality that this law is being interpreted by courts across India. How many people, and particularly the Mufassal areas and district courts and all that where this law gets interpreted, they have a different perspective at times. So perhaps change in law might not, or the two different legislation might not help. One example which I can quote, Chirag, if you allow me, that for example IBC, that was one of the finest piece of legislation, and with the complete timelines, it was addressing the concerns of the industry, etc. But the fact remains that have we done justice to this? Answer is definitely no, because interpretation and innovation is happening at a different level. So I think at times legislature is very, very proactive in terms of coming out with the legislation, but then somewhere we lose track and we interpret the law differently. So I think, from that perspective also, I don't think that the two separate legislations would help. But then from an argument standpoint, I think both the, views and counter views are, very good. Objective was the same for both the parties. But then I would go with Tejas and Bindi on this. Yeah. Thanks.
Thank you, Sanjeev ji. Justice Gupta.
I agree both sides were equally persuasive and, difficult to make a choice. But the fact is that what is the objective of arbitration? Arbitration is, as one of the participants have said, it's not alternative dispute resolution, it's a parallel dispute resolution. Parallel dispute resolution, if it is parallel dispute resolution, it means that the party should have confidence in the alternative system or the parallel system. For that, the quality of the award has to be good. The quality of would be such which parties can inspire confidence. Now, the difficulty is, the very difficult issue is, both have a different process of appointment of arbitration. In international arbitration, as one of the speakers have pointed out, is an institution which appoints arbitrator. But in respect of domestic arbitration, mostly in India, it is ad hoc arbitration appointed by the court. So if we have to harmonize the system of appointment of arbitrators, so that there is a uniform method of appointment, which if it is the institution will have a process of overseeing the process of the timeline, the fee, after the award is rendered, to have quality check, the mistakes, etc. All those things will become available, which are not available for ad hoc arbitration. So the process, you can have separate law or a same law doesn't mean it. While interpreting one law, you will always depend upon you will rely upon the other law. The question is the difficulty has arisen because the different grounds of challenge had been made in respect of international agreement award and that of a domestic award. We should avoid the distinction. If it is in one country, you can't have a more ground of challenge of domestic award than in respect of international award. The grounds of challenge should be same. The process of appointment should be same, so that we can have a process. Everybody knows that what should be the ground of challenge, what is the process of appointment of arbitrator. It will be better rather than, I would say that instead of taken divergent views both ways, I would advise a middle path, that we should have a common law, but with parity of appointment of arbitrator and for setting aside of the award. One of the panelists have said that the court should be given power to modify award. I have not examined it, but looking into the argument raised, I would say that once power to modify award is given to the court, then we are making court as a court of appeal. No, that will be totally unwarranted. If the court is given power to modify award, the court will go into the niceties that this part of award is good, this part of award is not good. Either the award should be sustained as a whole or should be set aside as a whole. In one of the recent judgment of the Supreme Court, where probably 18% award was compound interest was given, the Supreme Court has restored the award, which was set aside by two courts. That is to give the paramount importance to the arbitrator awards. That is what I think should be done, rather than giving opportunity to the court to interfere and to suggest modification of the award, which will be not conducive. Basically, the way is that there should be probably the act requires fine-tuning. Mr. Tejas is member of the committee. He can do that, where instead of having two separate laws, the same act can be modified, or same act he can suggest the new act with both domestic and international arbitration dealt with in a similar manner rather than differently. That's what I would say. So.
Thank you so much, Justice Gupta. And in such kind of debates, usually there is no winner. It's an arbitration which is winner. So, but I would like to bring in some questions here, right? Which, according to me, needs to be answered. For me, now we have Commercial Courts Act, right? And I believe justice under Commercial Courts Act could be efficient. We could have specialist judges. And ultimately, it is the duty of the state to deliver justice. Bindi mentioned about that there is a consent of the parties. Could I say it is a compelled consent, because parties do not have an option in form of courts efficiently doing. And when we talk about domestic arbitration, we are pushing arbitration, as I mentioned in my introductory note, as an alternative to court, not because there are no alternatives as in international arbitration. So how would you respond to such kind of claims, Bindi and Tejas? That we can make commercial courts more efficient rather than emphasizing too much on domestic arbitration?
So, of course, the commercial courts are doing what they need to do, but just so that I am making my point here. What I was suggesting, what I was trying to then say is, as I said, while I didn't hear a compelling argument for a separate law, I'm assuming, and on that basis, I had responded that the one compelling argument that I thought was compelling was the requirement of interference of courts in domestic arbitration, which today is not so much, given the strict challenge procedure that we have. And that would have been a one requirement is what I would have assumed. And therefore I was responding to that why would you want a larger interference? Because to start with, an arbitration, as we all know, an arbitration can start or commence only if parties have agreed to it to start with, right? It can't, otherwise you and I cannot simply sit and arbitrate. We need to have an agreement in place much before our disputes have arisen, or even after our disputes have arisen. But what we need is there to be an agreement, right? Now, at the time of making this choice, it's an informed choice that parties make. Why do parties select arbitration? I mean, I didn't want to repeat it then, but Tejas or somebody already carved out, right? The reasons why would somebody agree for an arbitration? It's effective, it's less expensive, it's less time consuming, and there is some sort of a finality attached to it, as opposed to, you know, when somebody files a suit or a proceeding in court. So you've kept all that in mind. You are intelligent enough, you know, to keep all this in mind and then choose arbitration. So then where is the question of wanting further court interference? You know, I mean, that's what I was trying to say, that when parties have actively, consciously chosen arbitration as a dispute mechanism, dispute resolution mechanism, then where is the question of further wanting court interference? That's the point I was making.
No. So, but for me, the question still remains, theoretically, yes, there is a consent. Theoretically, yes, parties do choose arbitration, but do they really choose arbitration? Especially in standard form of contracts, say there's an increasing trend in borrower and lender's agreement, where lender has a very weak bargaining position. There's an arbitration agreement. And in case of default of payment, lenders are being pushed to arbitration. They cannot afford arbitration to begin with, point number one. And
So
then, and most of these arbitrations which are happening, so what we have seen in Mumbai, there's one person representing bank who is an arbitrator, having a cause list of 200 matters, calling like judges all the parties. They are coming turn by turn. All the matters are being decided ex parte in the form of bank. So what I'm trying to say, when we think of arbitration, we are only thinking about large value disputes, but because we are making arbitration so popular, it is also being misused in many ways. So isn't it better to regulate more strictly than the international arbitration? Probably that's one of the questions which we could address. So
I have a slightly different view. Maybe Bindi, after you, I can.
Yeah, take us just 2 minutes. Just give me 2 minutes. No, so Chirag, insofar as banks and borrowers or lenders and borrowers are concerned, you are aware that now they have to only go to the DRT. You know, so that the position is quite settled now.
No,
so
less than 20 lakh rupees, it will not come under DRT.
Yeah, but I mean, then I don't know what kind of range you're talking about. Second, and more importantly, those unilateral arbitrators, unilateral appointments, even those have been done away with. So as and when, so you're right, we've had instances, you know, where you have one arbitrator having 200 arbitrations and all of that. But, you know, all that has been now, you know, after the disclosures which need to be made under the schedules to the Arbitration Act and all of that. So while all of that was happening, you're right. But as we move along, things are getting better, things are improving, even in the arbitration region. I just wanted to, you know, clarify that. And of course, over to Tejas to whatever further.
Yeah, then just to add to, I completely agree with Bindi. What I was trying to say is that we know all these problems, and that's why we have brought IBA guidelines on conflict of interest into our legislation. India is the only country which has the soft law incorporated into hard law. And that's where we have all these rules which will prohibit such kind of arbitrations. And if you're talking about bulk arbitrations, we should also use the technology, because yes, of course, when you need the loan, you agree to whatever fine print agreement is given. And when it comes time to return, you don't want to return, and therefore you have find faults with the arbitration. That's not the purpose of arbitration. Yes, arbitration is one of the means to resolve dispute. Like artificial intelligence can also play a very important role rather than doing it. If you really want to do it, like parking tickets in US and all, these are all bulk disputes which can get resolved. So I don't see any problem in those kind of disputes getting resolved through technology. But apart from that, I see your point. There are some problems, but we have by and large overcome all the problems in through our amendments or through court interventions. And I just wanted to do a rebuttal, but there was no opportunity, so I'll take this opportunity to say that look, legislative process takes very long. On an average, any law takes more than 2 years to come. So, and the courts are very quick. So why should we not use the court system to support the arbitration? Section 5 being the most important section in the entire act, is which limits the judicial intervention to only what is provided under the act. So we should, in fact, make use of it rather than going into or thinking too much about the problems of arbitration.
Yes, definitely. Let's do the post-poll debate, post-debate polling. Post-debate poll, I've launched it. So please give your views. Results are coming in. Kindly hurry up. Results are still coming in. Dear attendees, please hurry up. It's just a yes, no. It shouldn't take that much time. I think results are still coming in. I will stop now and poll. Okay, I will first share the results of pre-debate poll. These are the results. 73% yes, 16% no, 11% don't know. I will stop sharing this. This is post-debate poll and I'm sharing the results now. The positions have highly tilted after the debate. So we could say there are two juries, one in terms of audience, which have one set of notion, and one in terms of the jury we have. But yes, I believe, I understand that in terms of academic arguments, it has been a real rich experience in terms of how we have been able to put both sides of the argument, because as we say in law, there's no one single truth. So there's no final truth. We are always amenable to changes. It could be in form of amendment within the law, or it could be in terms of creating altogether a separate law. But we must evolve, we must adapt. And I think that's the feature of our country. We are taking constant efforts to become a pro-arbitration country. So that's, I think, the positive outcome of this debate. I also see there are a few questions by the attendees. Do we want to take them? As
So
we
Chirag, who wins according to you?
Yes.
Which team wins in terms of the jury?
No, as I said, nobody wins. Arbitration always wins. Intellectual engagements always win.
When I need to work harder.
Tejas has been able to turn some tables.
Yeah, but
Yes.
we need to work harder, Tejas, because we have not been able to defeat the motion entirely. We are not in majority.
Right.
Yeah,
right.
that is true. It's true.
So we need to meet for a cup of coffee or something to work on this further.
Yes.
But huge success, 73 to 56 is not bad.
It's a great success. Do we also want to take two questions before we close the session? There are two questions.
Yes, absolutely.
One question is, current mediation bill, it also has within the law both international mediation and domestic mediation as part of same law. So does it show the intention of the government that that's how they want it?
So the reason why we have it is that we are signatory to the Singapore Convention on Mediation, and that recognizes the obligation. Like New York Convention, we are also now going to recognize the negotiated or mediated settlements entered into outside India will be enforceable within India. So that is the reason why we have this dual system. And again, it's a consolidated law on mediation. So we need to achieve what we have achieved in arbitration, also to have a comprehensive law which deals with the law in mediation. The idea behind this particular act is also to give sanctity to the mediation process. As of now, we have the conciliation as part 3, which is slightly different from mediation. So once we have the mediation act, we can also use it at parallelly with arbitration, and we can have a hybrid model of ARB-MED, ARB-MED, which can be adopted like what we have in Singapore. So that's the reason why we have both in domestic as well as foreign mediations, and the reason for that, according to me, is Singapore Convention on Mediation.
Yes, yes. I think the second question is already addressed in the debate. So we need not take it. Any final comments from all the speakers?
I wanted to know Vyapak's views after the debate.
I think he has
Vyapak
left.
was in a meeting with Mr. Okay. So that's why he couldn't join the panel and he chose to become speaker. So that's why he must have left.
Okay.
Yeah. Yes. So if there are no final comments, I would like to say thank you to all the esteemed panelists and our esteemed and distinguished jury members. I would also like to thank all our attendees who have joined from be it Maharashtra National Law University, Mumbai, or other parts of India. Thank you so much. It was a really enriching experience. And thank you from the bottom of heart. We look forward to host all our panelists in the future events as well. And I hope we could give shape to the report which will come as an outcome of this debate, and we can collectively discuss it and submit it to the committee as well as government. Thank you so much to everyone.
Thank you.
Thank you very much, Chirag.
Thank you.
Thanks, everybody. Thank you.